Good afternoon, everyone. I'm Tim Richards, Technical Services Manager of the Managing General Agents Association. On behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by Mills Reeve with non-financial misconduct, unblurring the lines. I'd just like to run through a few housekeeping points. Please ensure your microphone and camera are turned off unless contributing. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these questions will be asked and answered at the end of the event. And if we run out of time, questions will be answered post-event. This presentation is accredited for CPD hours if relevant to your ongoing professional development programme. This briefing is being recorded, and a link to the recording will be issued post-event, together with the slides and our feedback survey. Please take the time to complete our survey. It takes no longer than two minutes and allows us to continue to deliver the best possible future events to our members. So, as a recap, today's briefing is non-financial misconduct, unblurring the lines, delivered by Mills and Reeve. So let me introduce you to our presenters, Andrew Secker and Ramsey Oscar. Andrew specialises in employment law and is also head of the firm's London office. Andrew works with his clients to navigate the employment issues they face, taking into account their culture, ER strategy, and approach to cost and risk. His practice covers a range of sectors, including financial services and insurance. Alongside his technical expertise, Andrew's clients value his approachable nature, practical advice, and ability to deliver innovative solutions. Ramsey has considerable experience in helping clients resolve employment law issues, particularly litigation and complaints, often with overlapping contractual issues. Ramsey has been involved in a number of complex matters for businesses regulated by the FCA, including discrimination and whistleblowing claims, and advises on restrictive covenants and team moves. Ramsey is also recognised as a rising star in the Legal 500 in 2022, 2023, and 2024. So without further ado, let me pass across to Andrew to begin the briefing. So Andrew, over to you.
Thank you, Tim, and afternoon, everyone who has joined us today. We are really pleased to talk to you this afternoon about non-financial misconduct, a topic which has been increasing in focus for the last 10 or so years. The intention very much is to demystify it or unblur the lines, or just to make it a little bit clearer than perhaps it is at the moment. And we're going to do so by talking to you for about 45 minutes to leave some time for some questions. And we're going to start by unpacking a couple of the really big topics. We're going to look at what is non-financial misconduct. And we're not going to just cheat and say it's everything other than financial misconduct. We assure you we'll give you a bit more detail on that. We're going to also explain why it is a regulatory issue already, but also then dig into some of the further potential reforms in this area. And in doing so, we're going to pick up the other three items that are on this first slide. So looking at fitness and propriety, conduct rules, and the interplay between employment and regulatory considerations. All of this is with an aim for delivering 5 key learning objectives for each of you today. I've put those on this slide. It's what I'd call a Ron Seal slide, so it does exactly what it says. So I'm not going to talk to it particularly other than to pause, let you have a quick read, and then I'll pass on to Ramsey, who's going to unpack what we mean when we refer to non-financial misconduct.
Thank you very much, Andrew. It's good to speak to you all this afternoon. So the starting point is often to think about what non-financial misconduct actually is, and unhelpfully there isn't an exact definition as such and no list as such that we can refer to. But generally speaking, it's any behaviour that goes against the values and principles of an organisation and that has the potential to cause harm to individuals or the reputation of said organisation. So as set out on the slide, this can include misconduct such as conduct relating to harassment, discrimination, bullying, and also physical violence. Now, we'll come on to speak about conduct that's inside or outside the workplace shortly, but the FCA does state that the non-financial misconduct we're talking about here may well be either in or outside the workplace. And we'll talk about some enforcement action and some example scenarios and cases a bit later on this afternoon. But we will see that enforcement action has been taken in relation to violence, in relation to evading train fares, and also sending inappropriate emails or messages in the workplace. So essentially the message is that the non-financial misconduct doesn't necessarily have to have a financial impact on the organisation. The regulator may well be interested in serious consequences to an impact on well-being of its employees, customers, and indeed stakeholders as well. So we'll pass on to Andrew to talk us through why non-financial misconduct is therefore considered a regulatory issue.
I mean, very much the answer to the question why it's a regulatory issue is because the FCA says it is. But if we can dig into it a little bit more in more detail, we've got on this slide a quote from Megan Butler. It's a famous quote taken in a written response to the Women Inequalities Committee, which was looking at that stage at the response to #MeToo in the context of financial services. And whilst it's absolutely right to say that non-financial misconduct, particularly in the context of sexual harassment, is something that all organisations, whether in financial services, in any walk of life, is something from a societal good and from a perspective that has to be addressed and managed. What I think you can take away from this quote beyond that is what the FCA considers is that it's actually symptomatic of a wider problem. So if there is a culture which allows things like sexual harassment or other forms of bullying and harassment to almost go on, what their concern is what that means about the organisational integrity from actually, are you driving away the best talent? Are you ensuring that good decisions, or what they've put here is best business choices, are made, and the best risk decisions? Because essentially a key driver of a lot of financial services offerings is how you manage risks. And essentially, if you operate in a culture where people don't speak up and there is conformity, that is a risk issue. Now, there have been a number of subsequent clear messages from the FCA as to build on from that as to why they think that non-financial misconduct or the failure to address it becomes a regulatory issue. But it's right to say that some of the reasons that people are concerned is that the current status is a little unclear. So, for example, if you look at, and we'll come on to this in a moment, the conduct rules which apply to financial services staff, the FCA handbook doesn't contain a single example of non-financial misconduct. So the misconduct that they're concerned about primarily is all aimed at financial misconduct. So it's not clear to a number of organisations how the non-financial misconduct fits into this regulatory reform. Now, the FCA, in conjunction with the PRA, has been consulting, and it was going to be introducing a new regulatory framework to look at how it deals with diversity and inclusion as a result of a consultation that took place in late September and December of last year. And Remzi's going to touch upon that a little bit later. But a core part that came out from that consultation is proposals to really integrate, or perhaps rather clarify, where non-financial misconduct is relevant in three key areas. And those key areas are: how is it relevant to the assessment that carries out on a yearly basis about the fitness and propriety of individuals working in financial services? Secondly, to what extent is non-financial misconduct deemed to be a breach of the conduct rules? So something that would trigger a notification to the FCA and serious consequences, and we'll come on to some of those consequences as we go later. But ultimately, as well, the third area, and this is probably the biggest stick that the FCA has threatened it might use if firms don't act to address the sexism that they or the cultural issues they've identified in financial services. And I should absolutely make clear this is looking at a sector-wide perspective. It's not looking any organisations, and I appreciate many organisations on this call won't recognise some of the behaviours that the FCA is talking about here. But the ultimate stick is to look at the suitability criteria, so whether or not you'd be authorised to carry out financial services work. Now, the idea of this is to develop a clear set of rules, as is currently the case with financial misconduct, to guide employers in how to walk the walk and understand where non-financial misconduct fits into those key areas. So in essence, it becomes an inherent part of the regulatory framework. Remzi, do you want to then look at fitness and propriety?
Thank you, Andrew. So as Andrew's mentioned, this sort of underpins the regulatory framework, broadly speaking, and we have the existing regime on fitness and propriety in front of us on the slide. And this is the fit and proper test, which is the standard that the FCA expects firms to apply to its senior managers, certified staff, and in some circumstances, non-exec directors. So firms are required to assess this fitness on an ongoing basis and ensure certification at least once a year, depending on the role. And there is guidance at the moment set out as to what the regulator expects in terms of the categories to be considered. And there's sort of three main elements as to the assessment, and that includes honesty, integrity and reputation, competence and capability, and also financial soundness. Now, in terms of non-financial misconduct, the FCA treats non-financial misconduct as potentially relevant to honesty, integrity, and reputation. And in some cases, this can also be relevant when it comes to competence and capability too. Now, the current version of the handbook provides guidance, as I said earlier, about how firms ought to be assessing honesty, integrity, and reputation. And there's a non-exhaustive list of the types of factors to be looking at. It's clear that it's a broad reaching assessment, so it can also include personal matters insofar as these relate to an individual's suitability to perform their function, or if non-financial misconduct is relevant to their particular job, function, or role. So it may well be that the misconduct both within and outside the workplace is therefore relevant for the purposes of assessing if someone's fit and proper. But there are some changes on the horizon on this. And as Andrew mentioned, the consultation that was in place between September and December, which ended in December, was looking at some draft guidance. So there's a draft section of the FCA handbook proposed where the FCA proposes to explain in more detail how non-financial misconduct will actually form part of the test for fitness and propriety. And it's very clear, it's sort of expressly stating that bullying and similar misconduct in the workplace is relevant as to whether someone's fit and proper. And similarly, serious behaviour in a person's personal or private life may also be relevant. And what the FCA is seeking to do is to give express examples of non-financial misconduct, and specifically give examples about any sexually or racially motivated offences as well. So whilst the proposals don't necessarily change the existing position in relation to non-financial misconduct when we're looking at whether someone's fit and proper, the FCA feels that adding this extra clarity and this extra guidance is likely to help in terms of consistency, and it's likely to assist firms when they're interpreting the rules, applying those rules, and potentially it's looking like they're proposing to be more consistent with other regulators in their approach, similar to the Solicitors Regulation Authority, for instance, and in the way that they look at solicitors and assess whether they're fit and proper. So that we'll talk a bit more about what else is on the horizon, but that's the sort of whistle-stop tour of fitness and propriety as it stands and what it's looking to potentially look like going forward. I'll pass on to Andrew to talk a bit more about the conduct rules, which makes up the other part of the regime.
So thanks, Ramsey. Just going back to a little bit of basics, because I think it's really helpful to kind of reset to go forward when we look at what's proposed. But what many of us on this call know off by heart perhaps is that anyone in a financial services business, say for those carrying out ancillary duties, are subject to conduct rules, and there are 5 core conduct rules which apply to said pretty much most people in financial services. And the one in which the non-financial misconduct it arguably applies is the first one, which is to act with integrity, which links back to the fitness and propriety test. So you can begin to see how these things link together. Now, in the handbook, what they've explained is that integrity really means that the extent to which someone acts honestly, transparently, and ethically. Now, just remember those three words: honesty, transparency, and efficacy. Oh, gosh, I was drinking water, by the way, nothing any stronger on a Tuesday afternoon. We'll come back to that when we look at some specific examples of how these conduct rules have applied. But as I said at the outset, in all of the examples of of integrity, they refer to, for example, misleading clients, falsifying documents. There's not a single example at the moment of non-financial misconduct, which is something they're looking to change moving forward. Now, in addition to those basic conduct rules, senior managers carry out and are subject to 4 additional rules. And the first 2, again, are the most relevant in the context of understanding why non-financial misconduct is a potential breach of risks of breach of conduct rules for a senior manager. And what it's really getting at is essentially putting some onus on saying, well, you're not necessarily responsible for why someone has behaved in a particular way, but what have you done to build a culture in which those things have taken place? And quite frankly, what have you done when those sorts of issues have happened? And so they're trying to get to this point where there's some collective responsibility on the senior managers to ensure that not only do they make sure the culture is right to try and eliminate as many of these things from happening, because no workforce is perfect, but then they're trying to make sure that there's some consequences so managers can deal with this and respond in an appropriate way. And we'll come back to how that's quite relevant in terms of some of the information that the FCA has been seeking from insurance businesses since February of this year in some of the correspondence it's issued. But as I said, from a conduct rules perspective, there are 2 aspects of this. There's the integrity piece, and then there is the specific point around managers' responsibility and the extent to which they could be culpable if they don't step up in that regard, which is quite neatly, because then we can just look at what changes are going to be proposed to conduct rules moving forward.
Thank you, Andrew. So currently the Code of Conduct rules in the FCA handbook include a non-exhaustive list of examples of conduct that would potentially amount to a breach of the rules, and that, as Andrew's already touched on, they very much sort of centre on dishonesty or misleading conduct in the course of providing financial services, so examples like misleading clients or the regulators, for instance. So the scope of the conduct rules is restricted, other than in the case of banks, to regulated activities. So therefore, unlike the fit and proper test, the conduct rules only apply to the performance of functions relating to regulated activities. And this means that behaviour that's unrelated to the workplace may raise questions as to someone's fitness and propriety, but it may well not likely constitute a breach of a conduct rule. So that's the sort of present position in terms of looking at the 2 regimes side by side and the current handbook. So currently the handbook doesn't therefore make reference to any specific non-financial misconduct. And this is one of the biggest changes proposed by the FCA in its consultation paper. So they now want to be specific. They now want to include express examples. So they essentially propose to expand the scope of the conduct rules to make clear that they do cover serious instances of bullying, for example, of harassment and similar unacceptable behaviour that we talked about earlier. So what they want to do is propose to amend the conduct rules by adding on guidance, and this guidance will cover the types of behaviour that would fall within the expanded scope, and also conduct that may well be outside of scope because it relates to an employee's personal or private life. They also want to introduce guidance and give some more clarity about certain circumstances where potentially, every instance of misconduct may well not amount to a breach of the conduct rule. So some more scenario-based examples. It's obviously a sensitive and difficult issue, as you can all gauge from what we've already been discussing, and it's very much the case that firms will need to be considering issues and scenarios on a case-by-case basis. And the FCA does make clear that the proposed expansion of the conduct rules doesn't cover non-financial misconduct in someone's private or personal life. And they want to be absolutely clear on that. So we can run through a couple of examples to help illustrate all of this and bring it all together. There's a table in the draft handbook as part of the consultation paper, which sets out some scenarios and then explains if they are likely to come within or outside the rule. So one example is misconduct against a colleague while working remotely. Is that covered? The answer is yes, according to the draft guidance. Another scenario is misconduct against a family member whilst working remotely. Is that covered? The draft guidance at the moment says no, there isn't a sufficient link to the actual work in that scenario. There's another example of misconduct against a member of the public whilst commuting to your place of work. Is that covered? The FCA also says no in their draft guidance, it's not. And then a final example that I thought was quite helpful is misconduct against a colleague whilst commuting to a work meeting or work event. And according to the draft guidance, that would very much be covered. So as you can see, it's not a very clear-cut situation. It's very much likely that there'll be grey areas. It might be that there's an incident that takes place at an event which involves a workplace team, but it hasn't been organised by the firm or organisation or the employer. And it might be that there's an incident that happens once an employee moves away from a workplace event to a non-official after party type scenario. So there's very much scope there, I think, for further guidance and for us to be waiting. It's a sort of wait and see approach, waiting to see the approach that may well be taken once we get the guidance in final form. But some takeaways from what's proposed is there's some relevant factors that the regulator really wants to highlight as to when we ought to be deciding whether conduct is within the scope of the conduct rules or not. And those are things like whether the employee was present on work premises, whether the incident or the conduct took place during business hours or it related to work matters, if it involved someone that the individual was dealing with on behalf of the firm or organisation, was the conduct via work equipment, so was it via a work mobile or work email, for instance, and was it the case that the purpose of the conduct was in any way to benefit the firm? So it's very much a wait and see situation at the moment, but it is intended that the new guidance will give some much more clarity. And as I said earlier, the intention is to sort of reduce and minimise the amount of misinterpretation potentially, and to allow a consistent approach. And with that in mind, we're going to talk you through some example cases and scenarios of enforcement action that the regulator has taken, and we can talk through the different types of considerations. I'll pass you to Andrew to kick us off.
And most of these all deal with that central issue that's applicable in the conduct rules and fitness and propriety, which is around honesty and integrity. So the first case is a case that came out of a team move case where there was a large team that moved from Talent Prebon to BCG in the early, I think about 2010. Resulting in a significant amount of court litigation involving Anthony Verrier. I may have mispronounced his name, but I doubt he'll be listening. And essentially, Mr. Verrier was the individual within the organisation who organised for his team to move. And in the course of the High Court litigation, there was a judgment issued which was, should we say, not particularly favourable to Mr. Verrier. So it found, as a matter of fact, that he encouraged individuals to breach their employment contracts with their current employer and produced documents asserting that they had been constructively dismissed, which was necessary for them to leave with immediate effect to join a competitor free from restrictive covenants, despite knowing that that position was not true. They gave a view on his evidence and said that whilst he stuck to the truth wherever possible, he did depart from it where inconvenient, or words to that effect. And he also had the same affliction that became him, as did Rebecca Vardy's PA, who lost her own mobile phone in the sea when presumably it was relatively unhelpful to have it. Mr. Verrier lost 8 Blackberries through the relevant period, remarkably when it was it might have been inconvenient for him to have to disclose evidence of what he was doing at various stages. So in that context, he was issued with a notice of prohibition that he was no longer fit and proper. And essentially what's quite clear is, whilst it's not just the fact that an individual has been found incredible in the true sense of the word, so not believed, as opposed to awesome, as I try and explain to my son. So not just the fact he's found incredible in court, it was the whole context and the nature of his honesty and integrity that led to that finding. The second case is one that's quite interesting, because there's a query as to whether this would be caught under the new regime. Involves a Jonathan Burrows, who was a managing director of a asset management business, and he was responsible for its customer function. Now, his practice, apparently, which came out when he was caught for fare dodging, was he would commute from a rural train station which was unmanned. And rather than buying a ticket, what he would do is he'd go all the way into central London. He'd get out his Oyster card when he'd come into the central station, and he would tap out. So because he didn't recognise him, he started the journey anywhere. He would pay the maximum sum for a tube fare, which was considerably cheaper than his commuting costs. So when he got caught, he ended up getting again a notice of prohibition. So on the basis of fitness and propriety. And there were 3 factors really that influenced the FCA on this. So firstly, that he was aware what he was doing was wrong. So these were not unintentional acts, they were deliberate acts. It wasn't a one-off, it was a set practice that he had. Secondly, he hadn't notified his employer of when he got caught. And essentially what they also said, it was inconsistent with the senior position that he held, and it was relevant that he had responsibility for a customer function. So those are 2 cases to start with, and Ramsey's going to talk about a couple of cases around the other 2 areas noted on this slide.
Thank you, Andrew. So one further case worth mentioning relates to care and diligence, and this is a case from back in 2017 where the FCA issued a final notice in relation to an MD imposing a financial penalty of around £37,000 for failing to act with due skill, care and diligence. And this involved an individual who was an MD in the investment banking division of his employer. Naturally, he had extensive access to confidential information in respect of forthcoming deals, and it was found that during a period of 4 months he was sharing confidential information about 2 clients via WhatsApp, and the messages revealed that he was sharing details about potential deals in the pipeline as well. And it did turn out that he wasn't necessarily sharing these messages from a competitive angle. So it wasn't that he was trying to do any damage necessarily to his employer, but it was found that it was completely inappropriate for him to be sharing such confidential information. And it seems that he was trying to show off to the recipients about the type of work that he was doing and the type of deals that were in the pipeline. So when the FCA were looking into this case, they decided that this fell into the bucket of not showing the care and diligence that one would expect from an individual in his position, particularly given his seniority and the type of information that he was privy to. So that was interesting because, as I said, there wasn't a sort of competitive element to his actions, but it was nonetheless found that he wasn't acting in accordance with that skill and care that was expected of him. Another case that I wanted to mention relates to sexual offences outside of work, and this goes back to 2021 and is a case involving an independent financial advisor, Mr. Frensham, who was issued with a prohibition order following a conviction for sexual grooming whilst he was an approved person. It's an interesting case because the FCA decided that he was no longer fit and proper to carry out his function, given this criminal charge. He referred the matter to the upper tribunal to be reviewed and looked at again. And the tribunal did agree with the FCA's approach, but they agreed for different reasons, which is why this case is very interesting. So it wasn't his criminal conviction that led the tribunal to agree with the FCA that he wasn't fit and proper. It was rather the circumstances surrounding that criminal conviction. And it was things like him not promptly notifying the FCA about the criminal offence, not notifying them about breaching bail conditions, and also not notifying the FCA that his professional body had declined to renew his membership, for instance. So as a result, it's quite an interesting case, because when the FCA and firms assess fitness and propriety for individuals, it means that the criminal conviction itself doesn't automatically mean that they're no longer fit and proper. The assessment is much wider than that. And the tribunal gave some guidance actually on the relevant factors to consider, and that included things like the circumstances of the offence, the seriousness of the offence, the explanations given by the convicted person, the relevance of the offence to the role, but also their conduct at the same time. So the amount of transparency with the regulator, the amount of cooperation, and essentially the fact that this individual had chosen to keep some of the information from the FCA. He had been rather vague, and he really wasn't transparent in terms of how the matter was developing, led the tribunal to agree with the FCA, but as I said, on slightly different grounds. And it's interesting because if you actually look at the final notices on the FCA website, those are rather brief. So at first glance, if one were to look at those, you may well think that it's the criminal side of things that means he's no longer able to carry out his role, but indeed there's much more to it. And I think this case is particularly important in demonstrating that there really was a need to link back to his honesty and his integrity in the broader circumstances. So it's very interesting, and it will be interesting to see how cases like this may well be decided once we see some of the changes that Andrew and I have been talking about this afternoon. And I think it's also slightly contradictory to what some of the statements that we're hearing from the regulator, which is that non-financial misconduct is misconduct, plain and simple. That's very well, but it may not be as plain and simple when cases are being decided for the purposes of enforcement action, certainly.
And I think that brings us neatly on to looking at the challenges that come out from these sorts of disciplinary investigations, and there's a number really. So one is that essentially you can end up in a situation where what you're looking at from a compliance side is at a higher threshold than on a normal disciplinary. So dealing with how the interplay is perhaps something that one's used to in the context of financial misconduct, but I think you're going to have to do that same balancing act and working out where you pivot from one compliance investigation to a disciplinary. The second is fear of retaliation. So it's more likely in the context of non-financial misconduct, it will come from someone speaking up. So how do you create that culture? That means considering how people report issues, how you deal with confidentiality in the context of investigating issues, and in some circumstances, anonymity. Likewise, I think it's an inherent nature of some of the examples of what constitutes non-financial misconduct, so bullying and harassment, that they are inherently subjective. We know from past experience that what one person's strong management is another person's bullying. And that builds on the point that Ramsey made earlier about the need for robust and consistent decision making, because of the personal, the consequences for those people who are determined no longer to be fit and proper, or to have who are going to be disciplined for a breach of the conduct rules. I think it then follows from that. There's a slight uneasiness as we get into some of these issues, because it's going to mean that organisations can have to delve into personal lives potentially in scenarios where they haven't previously from a regulatory perspective. So that will bring its own challenges around obtaining personal information. Indeed, thinking about the extent to which you ask for evidence held on equipment not belonging to the company, dealing with human rights, privacy, those good things. They're not insurmountable issues, but they are issues that have not perhaps seen in some of the contexts of compliance issues previously. And then I think it follows from that balancing act is going to be key all the way through. So balancing the rights of those who raise concerns, particularly insofar as they relate to actions directed towards them, and those against whom the concerns are raised, particularly in some instances where you have harassment that's going back for a number of years. You know, the trick is going to be to work out how you can do as full an investigation as possible, even accounting with the passage of time, and continuing balancing the interests of all the parties in it, that you act fairly and transparently. So I don't think that some of these are new challenges, but they are new in the context of non-financial misconduct, which I think it brings us neatly to kind of some lessons that we could take away from some of these. If we move on to the next slide, please, Ramsey.
Thank you, Andrew. So a key message from some of the example cases and from what Andrew and I have covered is that the impact of the behaviour is very much going to be critical, and employers need to be looking at whether the conduct affects the individual's ability to perform their role, as we've said, and it's having regard to the specific role and requirements of the profession overall. I mean, the rules are there and are designed to maintain confidence in the profession, so that's an overarching theme that the regulator and the employers and organisations should be alive to. And from our experience, cases involving power imbalance and abusive conduct potentially towards colleagues and other members of the profession are also likely to have more of an impact on whether someone's fit and proper, having regards to potential seniority in those circumstances as well. Looking at investigation again, as Andrew's already touched on, despite the challenges we've talked about, it's important that all cases are investigated to the fullest extent possible. It's a careful balance between providing the accused with adequate information, very specific allegations, and a complete set of facts, essentially an opportunity to defend themselves and their position. But it's also looking out for the alleged complainant and victim at the same time. It's sort of underlying theme, if you like, that the investigation and the consideration of all the evidence, as we've touched on with some of the enforcement example cases, is very much critical to draw out some of the wider circumstances that the regulator is often interested in. And it's very much then going to be a case for the basis for decisions to be made, and making sure that those decisions and the basis for those is carefully documented is important for obvious reasons, but it will also mean that the firm or organisation can clearly document whether the firm's able to carry on certifying a particular individual, for instance, as to whether they're fit and proper for their role, or whether a certification needs to be withdrawn, whether there is indeed a case also from an employment law perspective to take disciplinary action, and also in terms of any notification and regulatory reference considerations as well, which neatly moves us to regulatory references, which I know Andrew is going to talk to us about.
Yeah, I'm going to be brief on this, because we know from completing in regulatory references that this type of area touches neatly into questions on E, F and G, which respectively deal with the extent to which someone has been determined not to be fit and proper, whether they've been subject to disciplinary action, and whether aware of any serious misconduct. So bearing in mind the length of times that someone's regulatory reference covers, that emphasizes this importance of getting this right, because if you find that someone has committed any of those, if someone's not fit and proper, if they have breached the conduct rules, if there has been serious misconduct, it's going to follow them round and have a more wide-reaching perspective. Won't necessarily be completely determinative of what happens to them in their future career, but it does up the ante somewhat in terms of how these things are dealt with, which also then brings us neatly into kind of the FCA's wider considerations. And essentially, as we've alluded to on several occasions, what the FCA is really trying to do is to avoid people not speaking up. And they see that, yes, this is an issue for misconduct generally from a workplace perspective, but they see non-financial misconduct as a real problem from a cultural perspective, from a risk management perspective. And a good way to express this is we've got a quote from the PRA, indeed, on the next slide. I'm just going to pause to let you read it, but I think it gives you a real idea of how they're putting this in the cultural sense. Now, there may be a good reason why they're putting it in the cultural sense. It may be because there aren't that many cases of non-financial misconduct. And when we come on to some correspondence the FCA has been sending the insurance sector in February, I'll just explain a little bit about some statistics about the FCA's own investigations into non-financial misconduct. But this is really where they're upping the ante, which is why it's worth us just pausing for a moment to look at the proposals for the new regulatory framework on D&I.
Yes, thank you, Andrew. So on the slide, we've set out an outline of the specific outcomes that the FCA are looking to achieve when it comes to the framework and diversity and inclusion. And essentially, we can sort of group these into the following categories. They're looking at creating and maintaining healthier firm cultures, reducing groupthink, unlocking new talent, and a greater understanding of particularly diverse consumer needs and the need to provide for diverse consumer needs. So it's an interesting one, and Andrew will be a bit more specific on the next slide about some of the initiatives that the FCA are implementing to start gathering data and information to, first of all, analyse and assess the types of trends and patterns that firms and organisations are seeing in their workplaces. And then the step forward is to really drive forward this cultural change that seems to be very much top of their agenda when it comes to D&I, certainly from what we've seen.
And some of you may have received correspondence from the FCA. It was sent to, in February of this year, sent to Lloyd's managing agents and other parties as listed on this slide. I won't read it in full, but very much the background to this is, again, speaking broadly about the financial services rather than seeking to cast aspersions. There's been some concern about the lack of progress in some of these issues within the financial services. It's something, a theme that comes out very neatly from sexism in the city, and it's probably echoed in some of the statistics. So there's some stats produced on the number of investigations and complaints of non-financial misconduct received. So something like between 2018 and 2020, on average per quarter, there were 9 non-financial misconduct issues reported to the FCA. But within that same period, only 6 resulted in investigations by the FCA itself. So that's quite some dichotomy. You've got a lot of noise and rhetoric that's come out from the FCA, but actually, even in terms of the extent of reports to it and then investigations, that's not leading to huge numbers. So what they're trying to do is to get some information, and the intention is to try and collect as much information as one can to get an understanding of where non-financial misconduct occurs. And that's why they're asking to break down the categories of information in terms of types, so sexual harassment, bullying, discrimination, and the outcomes. And essentially what they're trying to do in building this is to work out to what extent does the FCA feel that the current measures that are proposed are going to go far enough, and to what extent, if they're unhappy with the actions that firms are taking across the industry as a whole, will they ultimately step in and intervene on a more severe footing. So I think the survey is quite interesting because it's kind of a reflection that the FCA wants to get a handle on the extent of visibility and reporting and data held on this within individual organisations. So which is quite neatly worth just summarising further developments on the horizon. And we've talked about the majority of these, but we've just put some key dates that take you through to 2025. We're not proposing to talk to them particularly in themselves, but I'll just pause to give you a moment to read it. But what we would like to talk to you about is what firms can do to protect themselves. So, Ramsey, you can talk to this.
Yes, so bringing this all together in terms of what this means practically speaking and what firms and organisations should be doing or continuing to do, there's some measures to prevent and address non-financial misconduct that stand out to us that are worth highlighting. The first is, if not already in existence, creating a code of conduct that specifically touches on what types of behaviours are expected and also the consequences of non-compliance with the code of conduct, and very specifically covering off non-financial misconduct almost sort of to align with the new draft guidance that we're expecting from the FCA, which will then help with the consistency piece that we touched on earlier. Training, as always, is going to be very important. Employees should be trained on the code of conduct, the standards expected from the FCA, their rights and responsibilities, and all of this specifically in relation to non-financial misconduct to unblur the lines, if you like, as much as we can, whilst we await further decisions and further clarity from the regulator. There should also be clear channels and information in relation to reporting and escalation. So the processes for reporting and escalating non-financial misconduct should be clear and communicated to staff, and staff should be aware of how to sort of navigate through these processes. We've also put on the slide there the importance of investigation and disciplinary action. So this is in the general sort of employment law sense of having the right processes in place to investigate allegations of non-financial misconduct, potentially with compliance overlap, of course, and taking disciplinary action where appropriate. And then finally, this is a very broad and wide piece around culture and leadership. It doesn't happen overnight. These types of changes naturally won't happen immediately, but the message from the regulator is very clear that they want firms to be creating a culture where employees feel safe to raise their concerns are taken seriously and dealt with appropriately. So really encouraging this speak up and speak out culture, and this then requires strong sort of leading by example, leading from the top, leading from strong leadership and commitment to promoting that culture of integrity and respect that the regulator is very much interested in. So these are just a couple of ideas, practically speaking, as to what one can do or continue doing in line to sort of align with the requirements and standards from the FCA, as we've seen from their consultation.
It's worth, I think, just taking a step back, because when we look at really what's going on here is that the FCA have talked a lot about non-financial misconduct, but have struggled to articulate how it fits within the existing regulatory function. And even with the proposed reforms, there are ambiguities. I mean, no one can really say what, you can't have an exhaustive list of potential scenarios. But what I think will be really instructive moving forward is the extent to which they align essentially a standard of expected conduct from people who are essentially professionals, no different to solicitors, doctors, and all those good things. And where they align those standards, there have been a number of cases, for example, of solicitors where their conduct outside of work has not been found to affect their duty or the public's confidence in them as solicitors. I think there's some famous words about expecting lawyers not to be paragons of virtue, but seeing where the FCA aligns itself and that threshold from what converts what may still be an ordinary disciplinary issue into an issue of fitness and propriety or a breach of the conduct rules as it evolves over the next few years, I think will be an interesting one, and it's one where I wouldn't pretend that we would know all the answers right now, because actually I don't think it's clear enough to give you a complete steer. But I think what we can do is take a nod from some of the directions that we've had in other comparable sectors, and in the way that essentially the FCA is trying to take the similar sort of approach as they do to currently to financial misconduct in understanding context, circumstances, and linkages with the actual regulatory roles and responsibility in individual exercises. So yeah, it's quite an interesting section. We've got some time now for questions, so we're just going to have a quick scan from them. I know Tim's been keeping an eye on them for us as well.
Indeed, Andrew. Yeah, so we do have a couple there, so happy to read those out, a couple of good ones. Anyone else, if you fancy asking a question, then do so now. We've still got about 10 minutes left, so now's an ideal time. I see another one's come through already, so I'll carry on quickly. First of those questions is, can you comment on whether allegations as well as convictions could give rise to action?
Yeah, I'll take that one. I think it's going to be quite tricky because it's going to depend on some of the allegations. That some of the allegations often that get reported are ones which are very, very serious allegations, particularly in the context of criminal allegations. I think it would be very difficult to take forward those in this context. It's not to say it's impossible, but allegations would need to be investigated for at least some form of corroboration. I don't think you necessarily need, in some senses, depending on the nature of the issue. So, for example, if behaviour towards a workplace colleague is said to have an element of criminality towards it, the fact that it's not reported to the police wouldn't stop you from investigating that as an organisation. But, for example, I've had the misfortune of having to advise a client where it was alleged that an individual had been arrested for offences relating to children. And it's really tricky at that point because the correspondence from someone at that point is, what are you going to do? Because you're employing someone that does X, Y, and Z, and that person hasn't had an opportunity to respond to the allegation. So it's quite tricky to see how allegations themselves could fall into the fitness and propriety, but that's not to say there won't be some extreme circumstances where it might.
Thanks, Andrew. And the next question is, are the levels of relevant misconduct objective, or does the impact on the individual mean they are subjective?
Okay. Ramsey, do you want to take that one?
Yeah, of course. It's a really good question, actually, because we can see how sort of wide-ranging the considerations are from a regulatory perspective. But it seems as though the starting point is objectivity, and then the impact on the individual very much depends on the gravity and the seriousness of the conduct or the criminal conduct that we're looking at. So from our experience, I think it's a sort of wide-ranging consideration where they may well take into mind the impact and the effect on the actual potential alleged victim. But generally speaking, you've seen that there's a distinction between how this is applied when it comes to the conduct rules versus whether someone's fit and proper. So it may well be that it depends on the individual's role to begin with, and then the considerations widen as we sort of go through the different categories, if you like, of what the regulator's focusing on. But I do think, I mean, Andrew, do tell me if you disagree, but I do think that there is a subjective element when it comes to the very serious type of sort of sexual harassment or racially motivated harassment or violence, or the sort of more serious end of the spectrum, if you like, and really delving into the impact on an individual victim, I do think may well come into play.
Yeah, I think you're absolutely right. I think what is relevant also to put in this context is in the regulatory area, the reason it's a regulatory issue is either because it's a serious act or someone has been intentionally or completely reckless in their actions. Whereas from an employment law perspective, for example, harassment is not what's intended necessarily, it's about how it's received. So that, I think, emphasizes a subjective assessment, because that person is going to have to determine, okay, were the actions serious, were they intentional, were they reckless, or did they just have that effect regardless of what was intended? So there is an inherent subjective nature to some of this, and a lot of these cases involve humans who are perceiving events really differently. So there is a subjective assessment. You can try and make it as objective as possible. I always think that it's important to investigate really full as full as possible to get as much level of detail, because I was unfortunate to have to, well, I supported a number of clients with a number of investigations that came out on the back of #MeToo. I think I added up, I was involved in about 30 sort of issues over about 2 or 3 year period. And the thing that often stood out was the most credible person was the one that could remember the little details. So it wasn't just roughly when it happened, they remember where they were, where things were positioned around a room, what colours, clothes people wearing. So some of that is going to be a subjective assessment of who you believe, but I think you've got to try and be as objective as you can in the evidence you use to, form your view.
Thank you. And we've got another question here. So do you think the FCA's changes may impact internal firms' disciplinary cases or employment tribunal issues? Will individuals be more likely to challenge internal disciplinary cases because of the risk of subsequent regulatory action?
Okay, well, that's a great question. I'm going to say a few things. So one is that I think in 2024, the thought that people wouldn't challenge disciplinaries is a really great, it's a great aspiration. But in my experience of employees, they challenge everything they can. So I think it will continue a trend. What I think it certainly will do is it will harden positions in terms of tribunals, because one of the things that happens when you deal with a breach of the regulatory rules is it really forces everyone's hands. As an employee, you can't look at really settlement in the same way as you could do for a non-financial services business. And equally, because of the wide-ranging impact on the individual, the only way they can go to expunge this from their record is to challenge the findings in an employment tribunal. No, you got this completely wrong. So I think it's going to mean that there's a wider category of issues which are dealt with in the same way as financial misconduct, which results in significant disciplinaries, are dealt with. So just more high stakes, because you're broadening those types of issues which become in those where you, as an employee, you can't settle them. As an employee, you must challenge them. Well, that's going to expand from financial misconduct to non-financial misconduct as well now. So I think we can see more tribunal a result of this. But let's also bear in mind those statistics I mentioned earlier, which was there were kind of essentially 9 issues reported per quarter to the FCA. So the degree to which there's going to be this type of issue, I think very much from an employer's perspective depends on your underlying culture. And as hopefully been explained in a way that doesn't offend anyone, is that some of the comments about the financial services sector, about the industry as a whole, if your organization isn't one that has these sort of endemic problems, then these changes won't necessarily affect you in the same way as the organizations who the FCA is looking really to target.
Great, thank you, and thank you both. That's the end of the questions. Just one comment, which is an early piece of feedback, which I'll read out. It's just, I need to depart. Excellent presentation, very interesting. Thanks. So positive comment there. So just remains for me really to thank you both for what was, I think, a very engaging, very interesting session and very valuable as well. So thank you for that. You can reach both presenters, so Andrew and Ramsey, at the contact details which are on your screen now, or feel free to contact me at tim.richards@mgaa.co.uk with any questions or introductions, and I'll be happy to pass these on. So thanks to everyone for joining us, and thanks again to Andrew and Ramsey. Please don't forget to provide your feedback and do look out for forthcoming MGAA events. I do hope you all have a productive afternoon, and thanks again for joining us, and see you all soon.